this. So just so for formalities, we will be having this webinar recorded, and if you have any questions during the webinar, you can use the comment. Type your comment, your questions on the comment on the chat box. They will answer the questions. We shall not entertain an audio-based question. All questions will be via the chat box. So we create your indulgence. We will soon commence. Having said that, I would like to thank every one of you for making our time to be here today. Good evening, and this evening here should be evening every other places. So I would like to call on the president online. Mr. President, are you there?
Yeah, Mr. Nago.
Okay,
good
great.
evening, distinguished ladies and gentlemen, and welcome to the first monthly webinar organized by the Institute of Information Management. 2021 was an exciting year as we're able to record a successful monthly webinar as we successfully executed the webinar starting from the month of January all through to December. So 2022, by the special grace of God, is not going to be an exception. And we're starting the year with a very important topic, which is also going to be facilitated by a renowned records and information management expert by the name Paul Mullon, who also happened to be a member of the board of the Institute of Information Management in South Africa. Paul, thank you for granting us this privilege to do this presentation. I believe at the end of the day, participants will have a lot to gain from your wealth of experience. Thank you, and have a wonderful session.
Okay, thank you, Mr. President, for the brief, for kicking off this great webinar today. Welcome everyone again to the Institute of Information Management for Africa. Here in Institute of Information Management, we deliver value. We train a lot of persons on information record management. We have levels in the institute. This we will talk about towards the end of the webinar. If Mr. President allows that, we'll do that towards the end so that we keep to time. Having said that, permit me to introduce the speaker for today, which is no other person than a member of us, with the board member in the South African Institute of the Institute of Information Management by Mr. Paul Mullon. Now, Paul Mullon joined the Institute of Information Management profession nearly 4 decades ago, starting off deeply as a technical in IT, managing mainframes. During the late 80s, he started to get involved more in software and specifically electronic document management systems. He stayed with the industry as it evolves and become the enterprise content management, which is known as the ECM, and then embraced the records management side as that took a greater emphasis. Very early on, he recognized the links between ECM, record management, IT governance, risks and privacy, and was one of the first to try and define the term information governance, and wrote the first information governance definition on Wikipedia. Information governance has formed the backbone of much of his work since then, and he has been in information governance consulting and training since 2006. Depending on the particular engagements, this could include record management, EDRMS, ECM, and more often than not, recently, developing and implementing privacy programs in African countries. Now, in this webinar, he's going to look specifically at how to implement a privacy program. Although most countries or regional blocks are developing their own privacy legislation. He uses the GDPR as a basis for this webinar, as many of the laws, including South Africa, have drawn heavily on this regulation. His organization, COR Concept, has the license to sell a privacy management tool in conjunction with IAM, though, through Africa, and this is used to show the various considerations and approaches that should be considered when complying with the privacy laws. So without any further ado, I hereby hand over the presentation to Mr. Paul Mullen. Paul, over to you and welcome. It's a pleasure.
Thank you very much and welcome to everybody, and really appreciate your time on a Tuesday evening. Very much appreciated. So as rightly said, I'm going to draw heavily on experiences from both what we've seen in Africa, but also the GDPR, especially as most countries have adopted at least some of the principles from the GDPR. And as we go through today, I will be talking about some overarching principles and some specific steps that need to take place to implement. And I'll be using the platform, not so much to show a specific tool, but to illustrate some of the complexities that need to be taken into account when implementing. So with that in mind, I'll be looking at general privacy, some underlying principles of privacy. And through this session, I'll use privacy, data privacy, data protection, very much interchangeably. At the end of the day, it really all refers to the same thing. I'll be looking at the types of things, the typical provisions that we see in almost every piece of privacy legislation. I'll talk a little bit about just some information formats. None of this should be strange to you or foreign to you, but we're recognizing more and more that you can't just look at paper when you're managing either records or a privacy program, but likewise, you can't only look at electronic. And the reality is that personal information might be held in data, it might be held in documents, electronic documents and records, and it might be held in some form of paper format. So at the end of the day, you need to understand all of the information you have, the implications for privacy, and how to manage all of that information. And then the majority of today's session is going to be a structured approach. And part of that structured approach is to be saying, if you use a tool, and there are a number of tools on the marketplace that can assist, then some of the things that you need to consider. As mentioned, we will leave questions until the end. So if you do have any questions or things you want to raise, please put it into the chat box, and then we'll pick them up and discuss them right at the end. If we had to try and synthesize the underlying principles that we are seeing apply across all privacy legislation. And when we look at that, we look at some of the stuff that's happening in America. We look at the data protection in the UK. We look at the GDPR, the General Data Protection Regulations in the European Union. In South Africa, we have our protection of personal information. We've seen the Nigerian data protection regulations. In Kenya, their regulations have been brought out. Botswana are currently bringing theirs out. So the reality is it's happening. It's happening in all countries. And if your country doesn't yet have formalized privacy legislation, it will happen. It's just a matter of time. So a lot of the principles we're talking about today can be applied, and you can start to get a heads up even if the legislation isn't in place yet. So these principles, the first one is that when we talk about information, in this case, we're talking about personal information, must be obtained fairly and lawfully. And obviously the key thing there is you can't steal someone's personal information. That underpins everything we're talking about today. Then, very importantly, it must only be used for the purpose for which it was gathered. And one of the key aspects of this is most of the legislation or most of the privacy laws are trying to get around abuse of personal information. And it's not only using it for direct marketing purposes, but it's also selling information onto other people, using your information to make money out of you by selling the information or doing something that they didn't obtain it for. But also is designed to protect against obviously hacking and ransomware and people stealing information and then using it for identity theft or other illegal purposes. The information that you have must be, we talk about adequate, relevant, and not excessive to purpose. And what we're saying there is that if you need, for example, personnel information to manage them as part of your HR team, you definitely need to get lots of personal information about them, including things like their qualifications, their family information, even banking information so that you can pay them. But there is certain information that there's, even as an employee or an employer, there's certain information you don't need to gather about those individuals. And likewise, when it comes to customers and partners and suppliers, you only should be gathering that information you need for the purpose for which you gathered it. And the word relevant here is important because it's saying the information you gather should be relevant for that purpose for which you need it. So don't gather information. If you're a bank, for example, don't gather information that you might want to use about somebody for some other purpose like gambling, whatever the case might be. Then it should be kept accurate, or should be accurate from the onset and kept accurate and up to date. And in many respects, when I look at this one, this is just good business practice. And in fact, many of the privacy principles we're talking about at the end of the day are really just good business practice. If you've got information, keep it accurate. It makes no sense to have misspelt names, to have incorrect addresses, email addresses, telephone numbers, because then you can't communicate with the people anyway. So it must be kept accurate, must be kept up to date, and accessible to the subject. And in this case, we see a strong link between freedom of information laws and the privacy laws. If you hold information about a data subject, whether it's an employee, a customer, partner, supplier, they have a right to know what information you hold about them. So at any stage, they should be able to come to you and say, what have you got about me? You should be able to produce it, and they should be able to then make decisions and say, well, that's incorrect, or I want it to be deleted, which may or may not be acceptable, depending on why you've got that information in the first place. This doesn't mean that you open up all your systems to the data subjects, but it does mean that you need to know what information you've got about them. You must be able to find it. You must be able to retrieve it. And an underlying theme that I'm going to touch on a couple of times tonight is that if you've got information, most organizations have duplicates, and in some instances, many, many duplicates. It's very hard to comply with the privacy laws if you have duplicates. So let's take, for example, the instance where somebody might have given you their information on paper. You've scanned in that paper. You've now got an electronic image of it. You've extracted some data from that document or from the image, and you've now stored it in your SAP or Oracle or your line of business system. So immediately in that case, you've got multiple versions of the same information. So if something changes, if they come to you at a later stage and say, well, I want to, I want you to delete my information, which version do you delete? You have to be able to find them all and delete them in order for you to fully comply. And you'll see that in the last bullet on this slide. I think it's no surprise to anybody that the electronic world, the online world, the World Wide Web has really exposed data in ways that's never been before. And hence most of the large data privacy breaches that we've seen around the world have happened with electronic information. So the onus on IT, especially, to keep that information secure has just become that much more significant. It doesn't mean that we don't need to protect the paper if we've got it. So if we've got it in paper, if we've got it electronic, wherever we've got it, whatever format it's in, we must keep it secure. This is one of the really strong underlying principles. And that's why in many jurisdictions, we talk about data protection rather than privacy. General data protection regulations, Nigerian data protection regulations. It's all about keeping that data secure, but the data is that data which contains personal information. And then the records managers amongst you will be delighted with this one, or maybe not. But the principle is that you gather it for a purpose. You use it for that purpose and only for that purpose. And when that purpose is finished, you should destroy it. And not only is that risk reducing for you, because the less information you need to manage, the better. It also cuts costs, but it really is just good practice. If you don't need it, why keep it? So these are underlying principles that we've seen really apply to all the privacy laws around the world. There's one that doesn't really stand out in these principles, but is an important consideration, and that is cross-border processing. And it's part of this keep secure principle. And what the laws generally say is, if you're in, let's just say Nigeria, and you have personal information about data subjects in Nigeria, you should keep that information in your country. Now, we know that most organizations have some form of hosted services where information could be kept outside the country. And it's not to say that in every country that's illegal, but there are a number of considerations. It must be in a country which has really strong privacy laws, must be kept very tightly secure in servers, etc. So just bear in mind that there's a strong consideration around sharing information across borders. If we look at it a bit further, and now we start looking at some of the things that you actually need to consider as you implement. And the first one is about accountability. And most of the laws talk about a data protection officer or an information officer. It's somebody who has overarching accountability within that organization to make sure that you comply with the privacy laws and you keep the information safe and secure. And in many laws, it's the most senior person in the organization who takes on that role of data protection officer or information officer, and they're the one who could go to jail. There's potentially significant fines, and in many of the laws, significant jail penalties for not complying. And the accountability is very serious. It really is something that right at the beginning of a program, you need to determine who's overall in charge, who they're going to delegate to. There should be formal delegations, and it should be monitored across the organization. The next one is, I mentioned earlier about lawful processing, or information must be processed lawfully and only for that purpose. And here, I've tried to put the most important legal basis for processing that we see. So the first one is consent. So if someone gives you informed written consent, where they have the ability to say, no, I don't want to do it. It's informed. They know exactly what you're going to do with that information. They give you that consent. You're allowed to process that information, but only for the purpose for which they gave it to you. But there's other times when it doesn't necessarily need consent in the same way. So for example, if a law, an occupational health and safety law, or a money laundering law, or some other law, or a tax law requires you to gather certain information, you have to do it. You don't need additional consent to get that because it's a legal requirement. Likewise, if you need information to fulfill a contract. And immediately here, I can think of a couple of examples straight away. The first one is your employee contract. So as an employee, you join an organization. In order for you to fulfill the contract of employment, you have to provide information. Obviously, your name and contact information, your next of kin, other family information, your address, but also your bank account so that the organization can pay you. And you need that to fulfill this contract of being an employee. Exactly the same thing would apply with a supplier, providing goods and services to your organization, and a customer where you're providing information or you're providing goods and services to them. So in all of those cases, there's a contractual obligation to provide certain information. It doesn't require additional consent. There might be other times where the information could be required to protect the interests of the data subject. So for example, somebody's hurt in a motor car accident, they go to hospital. Without having some information about them, you probably can't provide medical care. So there might be an incident where it's in the interests of the data subject. And then there's others where it gets a little bit vaguer. We could talk about some other legitimate reason, but we try not to go to that one because it's just a bit too vague. So the first three, consent, required by another law, or contractual, are typically the legal basis for processing that we would see. Then the next one is the purpose. So now we're gathering information. We're gathering it for a purpose, and we must know what that purpose is before we gather it. So if we look at the examples we spoke about already, you gather employee information for the purpose of them acting as an employee and you managing them as an employee. Likewise with a customer or a partner or a supplier. But then you only use that information for that specific purpose. And you must know what it is right up front. And hopefully already as we're starting to talk about these, you can see that know your data is so important. So you have to understand the types of data subjects about whose information you're gathering. You have to understand what type of information you're gathering about them. You have to understand how you're going to use it. So all of this needs to be understood, documented, and forms the basis for all your activities with that information. There are instances where you might gather information for a purpose, and at some future stage, it comes about that you need to use it for further processing. It's not necessarily illegal, but you do need to have a legal basis for doing that further processing. And that legal basis could be the same, could be consent, could be required by a law, could be contractual. Then we spoke about quality, and I've really mentioned all of this. The only thing I want to repeat here is when you gather the information, it can't be misleading. So when you're telling people what information you need from them and how you're going to use it, that must be accurate. In addition to obviously the information that you get being accurate. One of the difficulties here is updated. And what we believe, and once again, this is just good business practice, is every 2 years, every year, every 3 years, you should be going back to the data subjects with a standard questionnaire and saying, here's the information we have about you. Is it still correct? Do we still have permission to, or should we still be using it? And if there are any changes, what are they? So just good business practice to keep that information up to date. The next one is openness and transparency. And this really talks to the freedom of information laws. And those generally state, members of the public are entitled to know certain information, especially about government organizations. And in this case, if you've got their information, they're entitled to know what you hold about them. They're entitled to know what you're going to do with it, and at any stage are entitled to come and ask you. So this whole concept of openness is important. I've mentioned security, and this is security at all levels. It's protection against ransomware, it's protection against viruses, it's usernames and passwords, it's not sharing passwords, it's education of staff members all the time around phishing techniques that might be taking place. It's key controls for server rooms, it's key controls for physical filing cabinets. So once again, I'm not going to harp on it any longer. If you've got information in any format, it needs to be protected. Only the people who should have access to it should be given access, and they should only do with it what they're supposed to. And then the last one is data subject participation and rights. And what this is saying at the time that a data subject gives you their information, they need to know who you are as an organization. They need to know how you're going to use that information. They need to know, are you going to be sharing it with third parties? Are you going to be storing it in other countries? They're entitled to know what their rights are regarding objections. So if there's certain information that's mandatory, then if they don't give it to you, you can't provide the service to them. If it's optional, it needs to be absolutely clear that it's optional, and they should know what happens if they decide not to provide you with that information. At the time of gathering it, so whenever you gather that information, whether it's by a paper form, via electronic form, via a telephone conversation, that's the time that you need to tell them of their rights. The rights to participate, the right to refuse, the right to request access to information, the right to request that it be edited or deleted. So we need to update our forms and templates and data acquisition processes to make sure that at all of those times, whenever we gather data, that we inform data subjects of their rights. I've mentioned the forms a few times, and here I'm talking about forms of information. And the key message is that all content, whether it's in the form of data, paper, electronic, scanned in images, photographs, videos, it must be identifiable. If we've got it and it's about an individual, we must know where that information is stored. And if they do come to us and say, what have you got about us? We should know about all those various instances of information that we do hold. We've said must be deleted for the purpose for which it was gathered is over. And when I said earlier that the records managers might love this, some hate it, because often records managers and archivists and historians like to keep lots of information. Unfortunately, one of the key principles of privacy is we can't just keep everything forever. So developing retention schedules is absolutely critical. And those retention schedules must take into account the purpose for which we gathered it and when does that purpose finish. And as I said just now, whenever we gather information, the client or data subject must be informed who we are, how we're capturing it, and how we're going to use it. This just illustrates, I think, something that most organizations are doing now and some of the complexities of it. So if we look over here, the sort of paper world, very often we still get information in paper. Sometimes we're storing it as the paper. But sometimes we're taking that paper and we're scanning it. So then if you think what happens, we scan it, we keep the paper. We've now got a scanned in image as well as the paper. We also very often took the data sitting on this form and we entered that into our SAP or Oracle or whatever our line of business system is. Also, more and more, instead of a paper form, we're very often seeing that we now are accepting electronic forms, PDFs, populatable forms. So those are coming into our environments as well. So we've got all of these different, and voice is obviously another important one. So we've got all of this data coming in all of these different formats, and we end up keeping many different formats of the same data. And hopefully it's become quite clear already that the more data we have, the more different formats we have, the more different locations we store it in, the harder it is to manage it, the harder it is to keep it accurate and up to date, and the harder it is to comply when a data subject comes to us and says, well, please correct my data, because we've got it in so many different forms. And then once the purpose for which we gathered it is finished, and it comes now time to delete it, we've got to be able to find all of those various instances and delete all of them. So I really just hope it illustrates the point in this simple example here, that the more information we have and the more formats we've got, the harder it is to actually comply. Let me try and, I don't know how to delete my information. So let's go. So if we look now at a structured approach, and what I've just called it is the 10 P's of data processing or of data protection. The first one is planning. And I think the key message there is treat this as a program, treat it as a project. It's not going to happen by itself. So think carefully, what do we need to do? Who needs to do what? How long do we have? Are there certain deadlines that the law imposes on us? And you'll see just now that most organizations underestimate how complex this is. So do that planning early. Then participation. And when we talk about participation, here I'm talking about your data protection officer, any deputy delegated positions that you might put in place, departmental coordinators or champions. Who's going to actually make this happen? Who do you report to? Is there some board or steering committee that needs to be put in place? Things like incident response committees. So we need to start putting those structures in place right up front. People who can make decisions. People who can make decisions on things like retention periods, on security classification, on storage locations. Start getting those people in place as early as you can. In our experience, this next one, the probe, is one of the most important things. Because if you don't understand your information, and also if you don't understand the current status of your compliance, you really are going to flounder. So what you want to do is you want to map, firstly, what does the law say you need to do? And where are you? Put down a simple RAG analysis or some compliance assessment. And based on that, and use a risk-based approach, pick up the high-risk areas first and start fixing those first. But it all stems from understanding your information. You then need policies to be in place. And here, at least you'll have a privacy policy, internal, a privacy notice, which goes onto your website, and a couple of procedures. So there'll be a data subject request procedure. There will be a incident response procedure. There's retention disposal procedures. So at least those three and others need to be in place. You should also take a look at some of your existing policies, like your information security policy, to see if it's adequate. And you might have things like bring your own device or work from home policies, take a look at those and see if they expose you from a privacy point of view. You then need to educate your people, and this is an ongoing thing, and it's education both on privacy, on the policies and procedures, but also on data protection and things that they need to be aware of. You need to look at all your privacy-related processes. How and where do you capture information? Who's responsible for it? How and where do you store it? How do you respond to data subject requests? What about your marketing processes? So you need to look at your business processes which use personal information, and if needed, make adjustments to those. Then the protect, I think we've spoken enough about. Purge, we've spoken enough about, and that's the delete when the purpose is finished. Then systems, and what we're saying with systems is take a serious look at whether you need some form of IT solution to assist. And obviously this is far greater than just an IT system, but it really will assist you, especially if you're a relatively complex organization. And then the perfect one is really just saying this is continuous improvement on an ongoing basis. See what you can do to improve your program. So what I'm going to do is I'm going to, for a few moments, show you a system. And this is by no means saying you have to use this system. There are similar systems out there. There's a number of systems. But what it's hopefully is going to show you is just the formalization of many of the things you need to do. So I'm going to just open up to my I'm just going to stop sharing and share again. So hopefully you're now seeing a different screen. And what this is showing us is just a structured approach and a single source of reference for everything you need to do, with monitoring capability, and especially with ongoing training, a place where at a glance you can come to and make sure that you've done everything. We won't have nearly enough time to go through it in detail, so I'm just going to pick up on the things that you need to consider. So the first one here is, this goes back to our accountability. If you need a data protection officer according to your legislation, you need to appoint them. It should be a formalized role, formal delegation of authority, and you want to keep all of those documents, those signed acceptance letters, in a single location or repository. Then we need to take a look at compliance, and we want to start asking questions here. So, do we know all the places that we need data subject consent, and do we get it? Do we, if we use data subject information or personal information for direct marketing, do we understand and do we have consent to do it? I'll show you some of the questions under HR here. So under recruitment, in the recruitment space, what are we telling the people? So we can look here and say, we only use vetting under certain instances. We only carry out pre-employment vetting at some other stage. So we've got the ability to, and all of these format flows through everything. So we'll have a question, we will have a risk level, so either low, medium, or high risk. We can assign it to somebody to take action with it. And then we can say, well, have we not started? Is it in progress, or is it completed? This then allows us to, from a tracking point of view, see, has Paul, who certain tasks been assigned to him, done what they need to do? We can assign every task in this process to an individual, then we can track it. Likewise, we can track the status. So we can, with a single report, see all of the high-risk items. We can see which items are completed, which items are partly completed, and which items we haven't started. And that guides us through the journey. So really, just a really powerful tool to keep us on track, not only with the project, but the ongoing maintenance of the project, because that's something where we often fall short. So as the organization changes, as the types of data we gather changes, we can input that information into a system like this and monitor it on an ongoing basis. We typically do 2 assessments. We do an assessment which says, how are we relative to the legislation? So have we appointed information officer? Have we identified our information? Have we got the all the information, the policies, the information security policy, privacy policies in place? Have we trained all our people? So we can do an assessment report, and we also do a privacy impact assessment. And what that does is it highlights those areas where we create most at risk and what steps we can take to limit those risks. So very important assessments. The data mapping, and I'll just show you this because I do believe it's one of the most important things. We start off, we can put all the departments in the organization, and then for each department, we can look at that department and we can say, so for example, with customer service, we could say what data subject types. So within customer service, do we have consultant information, customer and client information, prospect and lead information? So we can document that here, and then we can document what type of information do we gather about all of those people. And also, we would then start to say, what is the retention period that applies to that type of information? So here we would do, for example, we would say something like banking details, and we would then say with banking details, what we look here, we could say, what is the data type? So we could say, where do we collect it? Do we collect it directly from a third party? Who is that third party? How do we collect it? We can say, does it contain special personal information, which could be biometrics, medical information, health information, information about things like political opinions or ethnicity, things which might be specifically stated in your legislation. Where is it processed? So is it on our servers? Is it stored in paper repositories? And do we share it with any other third parties? So immediately we can put together an extremely powerful and comprehensive inventory of all the information that we have. And if we haven't got this level of information, it's very hard for us to know what to do with it and ultimately to comply. Then from the governance documents, this particular system will generate the documents, but it doesn't have to. So you could write your own privacy policies, your own privacy notices, your own policies, your own procedures, or you could use a tool to templatize and create them for you. The employee awareness, one of the great things about a tool like this is you can put all of the things that you need to make your employees aware about. So we've got here the announcement of the program, privacy notice, working from home policy, data breach policy. We've got a couple of them here. And you can see these are all red because Paul Mullen hasn't read any of them. But we could create an email and say, we're going to send all of these to that person. We change the email, and then they would have to open them, read them, do the test, and acknowledge that they understand it. And that then gets kept as evidence of the awareness and training program. So really nice from an ongoing maintenance perspective. Then if you do have different legislation talk about processes or operators, it's people who perform processing on your behalf. So it could be third-party organizations, could be outsourced payroll, could be vetting companies, could be a third-party hosting company. You need to know and document what type of information you store with them and who they are. If you share information with third parties, you need to document that. I mentioned a data protection impact assessment. So here we're saying, with this type of data, what are the risks and what steps can we take to reduce the risk? And then these next two, from an ongoing maintenance point of view, if somebody does come to the organization with a request, you can record it here. You can record who they were, what the request was, what action was taken, was it closed? So you've got a single place to show what those requests were. And likewise, if there were incidents, you record those incidents here. So you've got a single source to say, here's what's happened, here's when it happened, here's exactly what it was, here's what we did to fix it, here's what we did to make sure it never happened again. If we had to notify data subjects, here's the letter we sent to the data subjects, and if we had to notify the regulator, here's what we did. So I think for small organizations, some will find this possibly too comprehensive, but the underlying principles and the underlying things you need to do remain the same, regardless of the size and complexity of your organization. So that was I wanted to show just a system. And as I said, that, it could be any system. I need to just try and hide this.
Yes, F5.
So my screen is it's on the wrong screen here, so I'm just going to redo my and
Okay.
hopefully you'll be able to see my screen again. And then I'm going to just finish with a few observations and comments. The first one is we saw this from the GDPR, and we've seen it in South Africa as well. That implementation took longer than you thought, was more complex, more expensive, required more input from more people than you expected. And both with GDPR and certainly in South Africa, we found that organizations weren't ready on the due date. In fact, we are seeing some organizations only starting their privacy journey now, which is 9 months after the due date. So, and don't laugh at them. You could find yourself in exactly the same situation. And then just once again, some final comments. If you treat this as a compliance initiative, just to comply, it's going to cost you money. You're going to get no benefit, and it's going to be a grudge purchase. So don't think of it only as compliance. Look at it and say, well, how can we benefit from this? How can we streamline our operations? How can we have more accurate information? How can we reduce the volume of information that we've got? How can we use it as a catalyst to get rid of outdated information? So see it as look for the benefits in it, and also see it as a starting point for a broader information governance program. So see it as improving your records management, improving your IT governance, as reducing risk in the organization. So try and bring together a number of those information governance initiatives. And my last point is, this is not a once-off. It's a program. So you'll start off with a project, but you're in it forever. Your organization is in this forever. It doesn't stop. So treat it as an ongoing program. Treat it as a journey, not just as a once-off project. So that's the formal bit over. We're open to questions now. I think what I'd like to do is hand it to the to the organizer, and if they can address the questions, I'll pick up on all of the questions as we go along.
Thank you so much, Paul. Thank you so much. That was a very insightful presentation. Yeah, we have a couple of questions, right? I have a question from Mr. Rotimi. So the first question is, every web page asks individuals to accept cookies or not. Is a lengthy document. So he says, are there any information governance issues when one accepts all cookies?
So I think the answer is, firstly, some web pages really do have lengthy documents. Others are very simple. I think many organizations don't put enough detail in their cookie disclaimer, and the information governance thing is, if you accept it all, and they do gather information about you that you don't want them to, you're potentially at risk. So are there information governance issues? Potentially. I think it really does depend on what cookies they gather. I think there's two things. One is, what do they gather, and also, how do they use it? So often they will gather it, and it's really simple. It's location, and they don't gather. They might gather IP addresses and location, but they're going to do nothing with it other than just identify where you are. They have no interest in who you are. So in a case like that, there's no real information governance issue to my mind. It's when it gets more nefarious, and when they start to abuse that information, and they start to then spam you and things like that, that's when they really are abusing privacy. So unfortunately, I think there potentially are information governance issues. You need to look at those cookie disclaimers, understand it, and be prepared to say, no, I don't accept them all. And then even go back to them and say, okay, well, I don't accept them all. What are the implications? And often they don't describe what the implications are, unfortunately. So you're left with a yes or no answer. I accept or I don't. And I think going forward, we're going to see organizations having to become more explicit about the cookies and how they use them.
Okay. Thank you very much. Mr. Rotimi, I hope that answers your question. Honestly, that has been there for long. There's a lot of people that put up a lot of things on the cookies. We want you to read. So it's too long. All right, so we have another question. It says, what data of information are protected from freedom of information requests?
So I think this is an extremely good question. And the reason I say that is people often think that privacy and freedom of information are totally in conflict with each other. And I think we should more treat them as opposite ends of the same continuum. So for example, if a freedom of information request involves information about a data subject, that should be protected, unless, and I think it depends on the particular legislation. But in our country, we're very specific about, if it's in the public domain, it's not part of privacy. So if your information's out there, you can't use privacy to hide that. But if we look at freedom of information, it's generally going to an organization saying, you've got information that I need for whatever purposes, for research purposes, or for the interests of the country as a whole. I don't think that overrides the right to protection of privacy. And I think you're going to have to do it on a case-by-case basis to say, if I release this information in terms of a freedom of information request, am I in fact impinging on the privacy of a data subject? And most freedom of information laws give the ability to refuse. And I think that's where people get it wrong. They think, well, freedom of information is you must just disclose it all, but it doesn't. I think you have as much of an obligation to say, no, I'm not giving it to you, and here's the reason why, as to just give it out. So no simple answer to that, but I would take that approach and say, does it impinge on someone's privacy? And if so, let's refuse it. And if it's really in the public interest, whatever, and that information is in the public domain, they can then appeal your request, and maybe you'll then have to release it. But first pass, if it contains personal information, I'd say don't give it out.
All right, thank you. The third question, why do you think a country will frown at saving data with third-party service providers based outside the country of origin of this data?
So it's a question that I think it's a concern for many people, because we all host stuff, we all like to host stuff, we like to use third-party storage providers, and it goes back to Rai's question earlier about outsourcing. And the key point here is some countries. So, for example, America, the American federal law says they can access your data. They can go to a service provider and say, I want to see all the information that you got on your servers. So if your country doesn't want your personal information exposed on a server in America, that's the reason why. That some of those countries are, their privacy laws are weak, and your personal information could easily be exposed in those countries. That's the reason why. So that they're trying to protect your data. So they really do have your best interests at heart.
All right, thank you so much.
So I think from my side, I'm done. So I'm going to hand back to Alexander, or to the president.
All right, thank you so much, Paul, for answering this question. Like, that has been a good one. Okay, it's more like a comment from Dr. Marvin. Okay. All right, I thank you so much, Paul, for that presentation. I think there are no other questions, and there are just comments. All right, so I will hand over to the president to give us some brief to talk about the institute, since we didn't have that at the beginning. So, Mr. President, are you there?
Yes, I'm here.
Yes.
I'm here. Yeah, thank you very much, Paul. That was a wonderful presentation, and I think we've been able to learn few things about data privacy. Usually we talk about the Institute of Information Management and the need for us all to be part of it and take advantage of all the various benefits that the Institute has actually got to offer us. As a professional institute, we offer different professional services, ranging from membership to training to certification and consultancy services. So you all will agree with me that we're in a world that is governed by data and information now, and the need to ensure that we all have adequate orientation and training in protecting, managing, and storing our information cannot be overemphasized. So the Institute of Information Management provides this opportunity for us to join the platform, learn best practices, share lessons learned, and also to network with professionals across the globe. Talking about our membership, the membership is actually in different grades. We have membership grades for students, we've got for graduates, we've got for associates, we've got professional grade, we've got senior professional, we have fellowship grade, which also is in two categories. We have the honorary fellowship grade. We have the professional fellowship grade. And lastly, we have the corporate grade, which is open for any organization or institution that is duly registered. And it's an opportunity for them and their employees to learn best practices in the field of data and information management. So to join the institute is very easy. You only need to send in your updated resume to our membership department, after which it will be evaluated, and the other requirements for membership will thereafter be sent to you. So we look forward to having you on board, and also look forward to another wonderful session in the month of February. We hope that you all will make it a point of duty to come out en masse, to come and enjoy and benefit from the wealth of knowledge and experience that the Institute has got to offer the world. Thank you once again, and do have a wonderful evening. Over to you, Mr. Alex.
Okay, thank you very much, Mr. President. Thank you so much for that, and thank you, everyone. Just a quick reminder that if you have any requests for the training slides, send your request to training@iam.org. I've sent that on the chat before. I think I have to put that again. The slides will be sent to members that are in good standing. For non-members, you will have to pay a fine for you to get that across. Okay. I think there's one question, just one. Someone sent a question. The question from Fusho. All right, I think someone has answered that question, right? Well, there was a question that was there, but I think Margaret has answered that question. Right. Okay, so for membership, you can send your request to membership@iam.africa.org. And you can also send for training request for the slide. You send your request to training@iam. Training@iam-africa.org as well. So we will see you next month for another interesting topic. We appreciate everyone for coming. So before we go, I would like to identify with the governing council members that are here to quickly give us quickly introduce themselves. I can see Mrs. Yemi Ezebube, you're here. Please, can you unmute yourself and introduce yourself? After that, we have Princess Tiwalade Fakunga, who is here. And this is Rhoda Faride. Right. Governing council members that are here, please, could you please unmute your mic and introduce yourself?
Okay, good evening.
We are waiting for Mrs. Ezebube to introduce herself. Is she there?
Yeah, she was here. I saw her here. I guess we were having some technicalities. She's here.
Maybe she's having some challenges with her network.
Yeah, she's online. She's still online. All right, so please.
The Vice President can proceed.
Okay, no problem. Vice President, please, can you go ahead?
Okay, can you hear me?
Perfectly.
Okay. I am Princess Tiwalade Fakonda, the Vice President of this great Institute of Information Management Africa. It's a pleasure to be here this evening, and I want to also welcome formally all the participants of today. You've been a wonderful audience, and I want to congratulate you for what you have learned. And I will not end without congratulating and thanking Paul for that great presentation. In fact, we have learned a lot from what he has presented. And I know that everybody here has also learned a lot. And In fact, we have learned a lot of new things about data privacy. And I hope another time he will come and deliver another lecture to us. We are all blessed, and we say thank you very much. May God bless you for the great job you have done. And I also want to thank the President, Ambassador Dr. Oyewole Oyedokun, for giving us wonderful people monthly to do our monthly webinar. We have started 2022 on a very wonderful, successful note. And I know the remaining 11 months will also be better and even greater than today's one, even though today is great. So every month we will be having greater, more successful webinar. Thank you so much from Dr. Oyedokun. And I want to let you know that your leadership is highly motivational and inspirational. We are all proud of you. More wins for you and all of us together. Thank you very much, Princess Tiwalade Fakponda.
Thank you, our able VP.
Thank you so much, our able VP. We have Mrs. Rhoda Friday. She was here. Mrs. Rhoda, are you still here? No, I don't think she's not here. She's not online. She was online with us, but she wasn't there. Okay, so Rhoda Friday is the Executive Secretary of the Institute of Information Management, but she's not here. All right, so we will move on to, please, kindly to turn on your cameras. We want to take the group pictures. Mr. President?
I'm here.
We want to have the group pictures. So if you are ready, everyone please turn on your camera so we can have the group pictures.
Wow.
I think we might have two groups.
Mr. Anago, can you do it from your end? I'm actually using a phone.
Oh,
and
okay. All right. Check the pictures for a second. All right, thank you, everyone. Thank you so much. We are done. No problem. We captured everyone. React, I could see you. No problem. Your picture background is captured, no problem. All right, thank you so much, and do have a good night rest, everyone. We hope to see you again next month.